Appointment powers. President can appoint ambassadors, federal judges, and other high-level officers with advice and consent of the Senate. Congress cannot give itself appointment powers. It can vest power to appoint inferior officers in president courts, heads of department or agencies. Inferior officers, usually those working under the presidentially appointed officers, can be fired by the appointed officer. Removal powers. President can remove high-level executive officers. Congress can statutorily limit president's power to remove all other executive appointees, so it can require good cause for removal. Congress can only remove executive officers through its impeachment power. Article 3, judges cannot be removed during good behavior. Impeachment. House of Representatives can impeach the president, vice president, federal judges, and federal officers for treason, bribery, or high crimes and misdemeanors. It requires majority vote. Upon impeachment, trial in the Senate requires 2/3 vote for removal from office. Immunity. President has absolute immunity from civil suits arising from official acts taken while in office. No immunity for actions occurring prior to taking office. Executive privilege protects against disclosure of presidential papers and conversations. Important government interests in criminal cases can override the privilege. So in Watergate, presidential documents and phone logs were disclosed for evidentiary purposes, which overrode the privilege. Pardon power. President has the power to pardon those accused or convicted of federal crimes, not state crimes. Exception is that the president cannot pardon someone for convictions leading to impeachment. President may also commute sentences. Congress cannot limit president's pardon power. Article 2 gives the president authority to make treaties, appoint ambassadors, and act as the commander-in-chief of the military. Treaties are agreements between the U.S. and foreign countries negotiated by the president. These become effective upon ratification of 2/3 of the Senate. Conflicts. If a treaty conflicts with other sources of law, these rules control. Conflicts with the state, the treaty prevails. Conflict with federal law, most recent prevails. Conflict with the Constitution prevails. Executive agreements are agreements reached between the president and foreign heads of state. They cannot be used for any purpose. No congressional approval is required. Conflicts. Executive agreements only prevail over conflicting state laws. Foreign affairs, generally, though Congress has some power regarding foreign affairs, such as to declare war, the president alone has authority to represent the U.S. in foreign affairs. Note, beware of answer choices in which another branch attempts to direct U.S. foreign representatives, such as ambassadors. Under the Supremacy Clause, federal laws trump conflicting state laws. There is an express preemption. If a federal law provides that the exclusive authority in a given area, it preempts the state and local laws in that area. However, preemption provisions are narrowly construed. So with implied preemption, if a federal law is silent on preemption, it implicitly preempts state law in 3 situations. The first is in mutual exclusivity. Federal and state laws are mutually exclusive. Complying with both is possible, so the state can set a stricter requirement if compliance with federal and state laws is possible. 2, state law impedes a federal objective. Or 3, Congress evidences a clear intent to legislate exclusively and or preempt state law. So an example might be immigration or bankruptcy law. If a state law doesn't afoul any of the above 3 situations, it is unlikely valid under the Supremacy Clause. State constitutions may provide broader rights and protections than federal constitution, but may not provide lesser protections that conflict with the scope of federal constitution rights and protections. Congress has broad commerce power when Congress is not acted. State and local laws may regulate local aspects of interstate commerce if the regulation is neither discriminatory nor unduly burdensome. The test is a state local law regulating interstate commerce is invalid if it A, discriminates against out-of-state competition, B, unduly burdens interstate commerce, or C, regulates wholly out-of-state activity. Examples: the following violate the DCC regulations, protect local businesses or requiring local operations, regulations limiting access to in-state products. Exceptions are that state law burdening interstate commerce is valid if either A, it is necessary to an important state interest, such as it furthers an important non-economic state interest and there's no reasonable alternative available. B, state is a market participant, so a state can favor its own citizens in buying and selling products, hiring labor, giving subsidies, etc. So like a tuition discount at a state university to in-state residents. Or C, a traditional government function. So a state can discriminate against non-residents if the law involves performative of traditional government functions. Or D, Congress approves and the state can burden interstate commerce where Congress has unmistakably granted permission. So states may not discriminate against non-state residents. This arises if a state law is intentionally protectionist and concerns rights relating to important commerce activities. So you want to look for situations where the state intentionally protects its citizens by discriminating against non-residents. Note, only protects citizens. Corporations and aliens are not citizens for purposes of Privileges and Immunities Clause. Analysis. Discriminating state law will be invalid if it 1, relates to civil liberties or commercial activities, and 2, it is not necessary to achieve an important government interest. So a state law intentionally protectionist in nature, there's no substantial justification for the discrimination, or less restrictive means are available. Examples. It is valid if the law requiring higher fees for non-state residents at public golf courses, higher fees for hunting licenses for non-residents, etc., but it is invalid if it's income tax on non-residents only, limiting bar admission to state residents, different fees for commercial fishing licenses. The 14th Amendment's Privileges or Immunities Clause primarily applies to restrictions on rights to interest in travel. It's narrowly construed and unlikely to be a correct answer choice. State taxes must have a substantial connection to the state and may not tax in a way that discriminates against interstate commerce. So a state may not use its tax system to help in-state businesses or discriminate against interstate commerce. So the analysis here is, does the state tax discriminate against interstate commerce? If yes, it is invalid and it violates the Dormant Commerce Clause. If not, it does not burden placed on interstate commerce outweigh its benefits to the state. There are 3 requirements. 1, there's a substantial nexus, so the tax must have a substantial nexus to the taxing state. So the item taxed is based on significant in-state activity. 2, there is fair apportionment, so the tax must be fairly apportioned. The state can only tax the portion of the activity connected to the state. Or 3, there is a fair relationship, so the tax must be fairly connected to the state. Benefit provided by the state, so the tax must, there must be some kind of government service or benefit. Intergovernmental immunity. States may not directly tax or regulate federal government property or activities without consent of Congress. The only exception is indirect, non-discriminatory taxes are valid if they are not unreasonably burden federal government. So like a state income tax on federal employees working in the state is okay because it's not a direct tax on the federal government.